we'll be doing CRM Problem 3 today. My group consists of Kalun, Colin, Jingyang, and myself. So the most common types of dispute at this current stage would be disagreement on defects internally and externally. So for internal wise, there will be meaning to be within the property itself. So there will be common disputes will be those about defects of the floor, cracks on the floor, cracks on the wall, leakage, blockage, flooring has an inconsistent layout, debonded tiling, and uneven gaps between the tiles. Hairline cracks on the ceiling, broken door, broken window, and for external wise, common on the common property, normally there will be leaf condition, darkened tiles, broken door, and spoiled bulbs. So all these disputes, owners of the property for internal wise should let the developer know as soon as possible, so that they are able to so the developer will be able to handle the defects as soon as possible. Next will be a dispute on rectification work. So when there's a dispute on the defects, like what I said just now, the owner should let the developers know about the defects, and after they let them know, the developer should engage their people to come down and carry out work to works to be done to make sure that the defects are done properly. So this chart over here is captured in BCA. So it's a flow chart of a step to getting the defects rectified. So firstly, after the developer hand over the property to the SP, the owners, when the owners found out that there are defects discovered within 12 months, the owner will notify the developer. So if the developer find out about the defects and within a month, they will, in a sense, a better developer, if a better developer get notified, and then they will as soon as possible handle the defect work. If not, if they are not handled within a amount of 1 month, the owner will have to engage their own workmen and notify the developer of their intention to carry out the work themselves, and to give the developer an estimation of the cost of the whole work done. So if the developer the developer should be notified within 14 days. So and they have to do something about it. So if it's not, they have to agree whether they have to give an answer whether they agree to it or not. If the developer does not give an reply to the SP, then the SP will carry out the work and recover the cost from the developer. So this is how defects are normally rectified. So next we'll be talking about repair not carried out to the SP satisfactory. So this kind of dispute is after the rectification work that the developer has done. So normally it'll be whether is it efficient or not, or whether did the developer respond to their inquiries, or do they do any follow-up work after the rectification work. Next we'll be talking about the needs and expectation of the customers.
Okay, so firstly, the expectation of customer will be that customer will expect the house to be in a good condition, which means that there are no damages, leakage, cracks on the wall, and etc. And secondly, they are expected to collect the keys. So the units are ready for handover after TOP has been issued and all other relevant licenses have been issued by the relevant government authorities. And once the unit is ready to hand over, the notice to take vacant possession will be served to customer through their solicitors. Once they receive the requisite full payment from customer may proceed to fix an appointment for collection of key. And for renovation of work, customer need to obtain an approval from the management office before carrying out any renovation works. This include alterations or additions to the unit. And the customer are also required to obtain a written approval from the relevant authorities and submit a copy of such approval to the management office for record before commencement of any works. And a copy of the application form can be obtained from the management office. Next. And customer need to apply for utilities in person at Singapore Power or online. It will take approximately 3 days for Singapore Power to activate the utilities, and a set of the application form will be given to the customer on the handover day. So customer also need to know the use of common facilities after they have collected the keys to their unit. The use of the recreational facilities are exclusive to residents and their guests, and purchasers who have tenanted out their units cannot use the facilities except as invites, invited guests or residents. And the use of certain common facilities such as tennis court and barbecue pit is subject to advance booking made to the management office. And lastly, the resident also must register their vehicle if they have any with the management office for administration or security purposes. And they can apply it for a car park transponder from the management office, and a copy of the application form can be obtained from the office as well. So only the homeowner or tenant who owns a vehicle and residing in the development will be issued with a car park transponder. So season parking for second and subsequent car owners will be subject to availability of lots after allocation for first car owners and are on a first come first serve basis. Next.
Next, I'll be talking about how developer can improve customer service for new homeowners. Firstly, establishing customer's journey. In order to improve customer service, a complete mapping of the customer journey must be established. From its initial research of a developer to handing over the keys, the overview stresses the process and identifies the people involved and all points of contact that a homeowner might have with a developer. It is key to identify each step along the journey and emphasize all potential problems that might jeopardize the relationship with the brand. The intent of mapping a customer journey is to visually understand all the important details of new homeowners and how they impact their decision making. Second one is providing consistent communication. Once the customer journey is defined, it is time to identify the steps to improve first. To build the key messages that will address the homeowner's pain points all along the journey, and to define a consistent visual identity. The way developers address their clients must be consistent wherever the path taken by him or her. Thirdly, automating qualification process. For an optimal experience, homeowners should be contacted as soon as possible after a request for information. The conversion rate is 25% higher if an incoming lead is called back less than 30 minutes after the request. Lastly is personalizing customers' experience. The qualification process enables developers to discover what is important to homeowners. It is easy to establish a personalized relationship with them, which will then boost the experience of new homeowners. Next slide. Next, I'll be talking about the roles of the managing agent. A managing agent is appointed by the Management Corporation, which is known as the MC, to handle the daily operations of the condominium development, or MCST. The appointed MA has the right to exercise the powers assigned to them by the MC, and their roles includes ensuring smooth functioning of estates, cleanliness, security, or scheduled maintenance, and reinforcing bylaws and handling questions from tenants or residents. They are also responsible for administrative matters such as booking of facilities, car park matters, contractual agreements, and council meetings. Lastly, they are also responsible for financial matters such as proper accounting and auditing of funds. Next slide. Next, I'll be talking about highlighting service touchpoints through the managing agent. In order to provide excellent customer service and engage the residents, the MA must be proactive in ensuring that his responsibilities are carried out and inspection of premises are done even before receiving residents' complaints. The MA must also organize annual general meeting AGMs or extraordinary general meetings EOGMs to provide a platform for residents to voice out their opinions. Lastly, the MA will take on responsibilities in managing other personnel such as contractors or security service provider in ensuring a safe and comfortable environment for the residents. Through this, the residents living within the MCST will be satisfied with the level of service and management provided by the MA. Next.
So what options do the disputing parties have in resolving disputes? There are three basic types of disputes resolution. Firstly, mediations. The goal of mediation is for a neutral third party to help disputants come to a consensus on their own. Rather than imposing a solution, a professional mediator works with the conflicting sides to explore the interests underlying their positions. So mediation can be effective at allowing parties to vent their feelings and fully explore their grievances. Working with parties together and sometimes separately, mediators can try to help them hammer out a resolution that is sustainable, voluntary, and non-binding. Secondly, in arbitration, a neutral third party serves as a judge who is responsible for resolving the dispute. The arbitrator listens as each side argues its case and presents relevant evidence, then renders a binding decision. The disputants can negotiate virtually any aspect of the arbitration process, including whether lawyers will be present at the time and which standards of evidence will be used. Arbitrators hand down decisions that are usually confidential and that cannot be appealed. Like mediation, arbitration tends to be much less expensive than litigation. So the most familiar type of dispute resolution is the civil litigation. It typically involves a defendant facing off against a plaintiff before either a judge or a judge and a jury. The judge and a jury is responsible for weighing the evidence and making a ruling. The information conveyed in hearing and trials usually enters and stays on a public record. Lawyers typically dominate litigation, which often ends in a settlement agreement during the pre-trial period of discovery and preparation. Next.
So the five common areas of disputes between condominium management and its subsidiary proprietors identified are interfloor leakage, en bloc maintenance fee, dispute with bylaw, and lastly administrative disputes. So the three disputes that I've chosen are en bloc, dispute with bylaw, and administrative dispute. The first one is en bloc, which Mandarin Gardens, which was built in 1986, had en bloc potential due to mortgage payments mistakenly becoming optional and the interest rate being reduced to zero. This made Singaporean mortgages extremely cheap and they were encouraging the en bloc sale. However, the proxy committee decided that there was a shortcut to making the en bloc sale go through if they are collaborated to turn Mandarin Gardens into the garbage dump of the East. Secondly, dispute with bylaw. This bylaw is regarding parking, which talks about a security officer being verbally abused by residents, and he has filed 3 police reports for harassment when he was only enforcing the condo's in-house rules. Lastly, for administrative disputes, 2 Chinese nationals at Simei Green condominium who were not residents assaulted Mr. Kwek, a condominium manager. The twin sisters also did not have a resident pass for the condominium. One of the sister, Tang Bei, was caught tailing other residences out of the side gate of the condo. Next slide. So, based on the 3 cases, I'll explain how each of the issues were resolved. For en bloc, in response, the condo MCST resigned en masse, leaving the estate with zero management. Later on, the proxy committee gave up on the en bloc attempt as the sale was ended as its collective sale agreement expired before meeting the 80% owner consensus requirement. Next, for dispute with bylaw, an incident occurred where a group of residents parked in the wrong spot for 30 minutes. The security officer, Mr. Sivaraja, had to clamp the wheel of the car. Soon after, the resident came back to confront him and verbally abused him again. The security had to stood his ground after the resident's confrontation. Eventually, the condo management came and told the resident to pay a fine to remove the clamp. To curb further abuses in the future, some condos may impose a parking fee on visitors parking overnight, while others require visitors to apply for free parking so that the security guard need not always check for illegal parkings. Lastly, for administrative disputes. This dispute was resolved under litigation as the twin sisters were crossing the line due to one of the condo staff needing to visit a hospital to treat his injuries. The district judge, Sarah Tan, convicted the sisters after a 20-day trial, fined Tang Bei 2,100 and the other sister, Tang Lei, 2,500. Although the offender Tang Bei claimed that it was self-defense, the claim was invalid as the video footage showed the sister attacking the victim in an unrelenting and vicious manner. Therefore, the twin sisters were fined and charged. Footage of evidences can be found online. That's all. Thank you.